Welcome to Season 5, Episode 10 of Fire Away, Rudner Law's online show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator and the founder of Rudner Law, as well as being your host of this episode of Fire Away. To remind you, Fire Away streams live online every month, and if you missed an episode or want to watch one again, they're always available on our YouTube channel. Please subscribe, on our Facebook page, and on our website. Very happy to be joined today by Brittany Taylor, who regular viewers will know. Brittany is a partner in Rudner Law and a frequent host of this show. So, Brittany, thanks for joining me today.
Thanks for having me.
Looking forward to this. So today we're going to be focusing on a legislative update, which may not sound that exciting, but these are things that you need to be aware of. And these are things that we've all heard about in the media. Issues like the right to disconnect, paid sick days, electronic monitoring, non-competition clauses being unlawful, and many more. So we're going to take the time today to review some of the more notable changes that either have come into force recently or will be enforced soon. And just remember that the law is always evolving. So obviously over the last couple of years, we've seen a lot of change in the world. We've seen a lot of notable court decisions and a lot of government legislation, which changes the rules of the workplace. It's really important to keep up to date, which is a bit of a plug for our firm blog, all of our social media platforms, and our newsletter, which you can sign up for. And I'm also excited to mention that we're doing another Rudner Law webinar tomorrow, titled Navigating the Hopefully Post-Pandemic Workplace. So you can go to our upcoming events on our website or click below and join us tomorrow. Or if you can't join us tomorrow, the recording will be available. Please register for the webinar, which will be live tomorrow at noon Eastern Standard Time. So let's get into this. Brittany, we'll start with two policy requirements that I think have got a lot of media attention, but in many cases, I think there's been a lot of misinformation or misunderstanding as to what these two pieces of legislation mean. So first of all, the right to disconnect. Why don't we start with that?
Yeah, absolutely. So, both of the policy requirements that we're going to be talking about, starting with the right to disconnect or disconnecting from work policy, apply to employers who have 25 employees or more as of January 1st of any given year. So for those employers who qualify for this year, they had some extra time, right? So they had until, I think it was June 2nd for the disconnecting from work policy. For the electronic monitoring policy, they had till October 11th to put these policies in effect. What's really important, and I think, Stuart, what you've kind of highlighted about both of these policies is that they don't actually create any new rights or entitlements for employees. And this was a big thing that we were seeing in the media, especially with the right to disconnect, and the name is a misnomer. I think that's part of the problem, is the name suggests that you're creating this right that didn't exist previously to disconnect from work, but that's not actually at all what the legislative requirements are. It's not about creating new rights or entitlements. It's about creating new requirements for employers, and those requirements are largely focused on disclosure. So just being open, honest, advising employees what the expectations are with respect to disconnecting from work, what the expectations are, or what kind of monitoring is present in the workplace, which we'll talk about in a little bit. But yeah, I think you hit the nail right on the head in terms of what do these policies actually do. Really, it's just requiring that employers turn their minds to these topics and create policies to advise employees what the expectations are in the workplace, rather than creating any new rights or entitlements for employees.
Yeah, and I think that it's one of the things we've joked about within the firm, which is we've often said you could have a policy which literally says that employees do not need to check their email on Tuesdays and Thursdays from 2 a.m. to 3 a.m. and technically you would be compliant. But you would not be compliant if you don't have a policy at all. I think that's an important thing for people to understand. So that's one point. Although one thing we've also said is this is a bit of an opportunity or a reminder to take that step back and think about what you want your workplace to actually look like and what you want the policies to be. Even though, because at some point there may be more requirements as to what the policy says, but for now, as you've explained, it's really just having the policy and certain details that are required, but there's no substantive requirements to them.
Yeah, exactly. So when we look at, what exactly needs to be included in your disconnecting from work policy, it's really sparse. It's basically just information. Like literally, this is what the description is: information on the employer's expectations on disconnecting from work. So, Stuart, as you said, you could say on Tuesdays between 2 a.m. and 3 a.m., we're not expecting you to check your email. Okay, you've outlined your expectations with respect to disconnecting from work. The only other requirements that are more technical are just that you have to include the date the policy was prepared, and you have to specifically call out the date any changes to the policy are made. That's it, right? So the ministry has been helpful in providing us with some guidance in terms of the types of topics that you may want to cover in your policy. So things like, we're using the reading emails example. That's one of the examples that the ministry has highlighted, is reading or replying to work-related emails during your off hours or once your shift is over for the day. Or identifying different expectations for different types of employees, right? For managers versus entry level employees. The type of communication, like even just highlighting things like, if you need an immediate response, the requirement is that you mark it as urgent. Like in the subject line of your email, you indicate it's urgent. So it's an opportunity for employers, like you said, to really kind of look at their workplace, figure out what are some things that maybe do need to be particularized or would be helpful to be particularized, so that everybody is functioning well, like a well-oiled machine together, and everybody has the same expectations of how quickly we're going to get a response to something, especially if it's out of regular business hours.
It's
Um, so I think that, you're right, it is a good opportunity for employers, but at the same time, I think one trap that employers have fallen into that I have seen with some policies that have been drafted is that the employer actually gives rights to employees that they wouldn't otherwise have. So they, in their own policy, are creating a right to disconnect, which otherwise wouldn't be there. So that's the one thing I think employers need to be careful of. If they haven't already drafted this policy, maybe they don't meet the requirements this year, but will next year, is to just pay attention that you're not going too far in the direction of actually giving employees more rights and entitlements than they are actually entitled to pursuant to the legislation.
Yeah, no, I think that's a really good point. And this gets back to a point we often make with our clients is, first of all, read your policies and make sure you understand what they actually say. But second of all, and it sounds self-serving, work with an employment lawyer to make sure you actually understand what the obligations are. And we see this all the time in the context of investigations and harassment policies. And harassment policies, which say, guarantee something like we will investigate complaints within 7 business days, when you don't legislatively have to do that. And in many cases, you can't do it, but you've now committed to doing it. Or accommodation, this came up recently where, by law, as most viewers will know, you have to accommodate certain things under the human rights legislation to the point of undue hardship. And yet we still see policies which routinely say we will do everything we possibly can to accommodate you, which is now a very different standard than undue hardship. And I know it sounds great and it sounds nice to say that, but you're creating obligations that you don't need to, just like you said, for the right to disconnect. So I wanted to move on to the other one that you mentioned, which is the electronic monitoring policy, in which, not surprising, I think we've all seen the news stories about employers who don't necessarily believe their employees are working when they should be, and so they use some sort of monitoring, keystroke monitoring or mouse movement monitoring to check up on them, as well as the more traditional, if you have people in the workplace, video cameras and that kind of thing. So again, we have an electronic monitoring policy requirement, which doesn't really set out any new rights. So maybe you can explain what that means.
Yeah, absolutely. And so I think the one thing that employers were really freaked out about when this policy requirement was first introduced is this idea that we're not going to be allowed to monitor our employees anymore. There's going to be some crackdown that's happening that says no more keystroke technology, no more video cameras in the workplace. And that's it, just like with the disconnecting from work policy, that is not at all what the ministry is saying. They're saying, yes, absolutely, you can monitor your employees, but you have to tell them, right? And this policy requirement has a few more specific nuances to it that are enumerated in the legislation. So we know that the policy has to include a description of how and in what circumstances you are electronically monitoring your employees, and the purposes for which any data or information collected through that monitoring are going to be used or could be used by the employer. So we've got a little bit more, I don't want to say substance, but a little bit more guidance in terms of what your policy has to include, what it needs to look like. And then, of course, we also have again, this requirement of the date that it was prepared, the date that any changes are being made. But the key here is, just like with the kind of disconnecting from work policy, the idea here is just communication, letting the employee know the situations in which they could be monitored. And when we're talking about monitoring, we're also talking really broadly. And Stuart, you kind of highlighted this. I think one mistake that employers have made that I've seen is assuming electronic monitoring only means what do we have on the computer, right?
Mm-hmm.
And there's a lot of other forms of electronic monitoring that happens, even just swiping your key card to access the building or to access certain restricted areas in the building. That is a form of electronic monitoring. GPS in vehicles is a form of electronic monitoring. So I think for employers, it's, making sure that you're casting a wide net when you're looking at how am I monitoring? And I would even almost take out the electronic piece of it and just be like, how am I monitoring, period, in order to really capture all the ways in which you are checking in or keeping track of your employees. But then you also kind of have to go that step further and think, why am I doing this?
And actually, before you even go there, I was just the one thing I'll add is talk to your IT department.
Right.
Because I was actually talking to an HR person recently who said they reviewed the legislation. They understood they had to disclose all their monitoring. As far as they knew, they weren't monitoring, and they had no intention of monitoring. So they weren't going to do anything at all. And then they talked to their IT department and realized, as you said, even things like they were tracking when people were logging in and out of their system. And because they were tracking that data, that now became something that had to be disclosed, or the key cards or the GPS, because they were tracking, especially their sales folks. They were tracking where their salespeople were going in the company cars using the GPS. So people may not realize that. So talk to your IT department and really take the time to think about it, because this is one of like the right to disconnect. This is a requirement that just requires that you disclose what you're already doing. It doesn't create any new prohibitions. So it'd be really silly to not comply with that because it's not that onerous.
Exactly. But it does, like you said, it does take a little bit of work to figure out, okay, make sure we're capturing all the ways that we're monitoring, and then also understanding why we're doing it, when we're doing it, and what the data is being used for. I know I had a couple of clients who I asked them, okay, so you're recording employees coming into the building with your security camera. What happens to the footage? And they were like, they had to go and ask their IT team, what do we do? Like, how long is it stored for? When do we ever look back at it? All of those questions that they just didn't know off the top of their head, those questions that they weren't asking or weren't concerning themselves with. So there is a little bit of homework that needs to be done in order to prepare the policy. And then the final thing I would just say is just even for employers who say, I don't do any of this, you still have to have the policy. If all your policy says is we don't electronically monitor employees, period, great. That's what you need to do. But you still have to have the policy in effect, making sure that you're making that really clear.
Yeah, no, I think that's a really important point. And the last, the best summary I heard of this is, people really need to understand that, like you were saying, this doesn't prohibit anything. And it's not a consent-based system. It doesn't mean you need to get the employee's consent. It doesn't mean you have to justify why you're doing what you're doing. All it means is that you have to disclose it as you've explained. I think people just need to understand that. And again, this will probably evolve over time, and maybe there will be things that are prohibited, but now it's just a disclosure-based policy. And the one thing I'll add, because this actually came up in a discussion a few weeks ago, we were talking about the technology you can use to monitor people's keystrokes and mouse movement, and I guess there were news reports of some companies who were checking, and if someone didn't move their mouse for a long period of time, then they were essentially deemed to not be working. So now there is the counter software, which will automatically move your mouse, move the cursor every now and then, which I think is hysterical. But I've been warning employees not to do that, because to me, if an employer finds out you're doing that, then all of a sudden, I mean, that's dishonesty, and that could be something that will warrant discipline, if not dismissal. So you really don't want to be doing that. But as we're seeing, it's like everything else. There's always measures and countermeasures, but you got to be really careful about doing something like that.
Yeah, absolutely. What a brave new world we're living in.
Like, what's the proverb? May you live in interesting times.
Well, we're certainly doing that.
Yeah, and these things keep us busy, so I can't complain.
It's true.
And we should clarify, by the way, the two things we've been talking about are Ontario-specific legislation. So I just wanted to clarify that. And I want to move on to another thing that was a huge topic of debate, throughout the pandemic, which was sick days, and how many sick days people should get and whether they should be paid or unpaid. And this is all, like most employment laws, governed by the jurisdiction you're in. So most workers in Canada are provincially regulated, which means every province has its own employment standards legislation. And then there's the Canada Labor Code for federally regulated employees, which are a fairly small percentage of our workforce. But there have been some developments, so I thought maybe we could cover that next.
Yeah, absolutely. So let's start in British Columbia. So as of January 1st of this year, employees with more than 90 consecutive days of service are now entitled to 5 paid days of personal illness or injury leave per calendar year. So this is pretty amazing. 5 paid days of sick leave in British Columbia. And again, the only criteria is that an employee is with you for 90 consecutive days, and then they become eligible for this leave. So that's really a really interesting development that came out of BC.
Yeah, I thought that they were I think the first province that's offered paid sick days. I mean, I think we had them briefly in Ontario.
Yes.
Prior to the pandemic, but that was during that brief period of liberal rule. And then the federal government has doubled the BC requirement.
That's right, and that this is really new. This regulation implementing the paid sick days at the federal level actually was just passed, and I think it was last week. So what that regulation does is it gives employees 10 days, or I should say up to 10 days of paid personal leave on an annual basis. And this is actually kicking in as of December 31st of this year. So starting December 31st, 2022, employees who have been continuously employed for at least 30 days, so it's a lower threshold, will have access to 3 paid sick days. And then as of February 1st, 2023, they're going to acquire a 4th paid day of sick leave, and then they're going to continue to accumulate paid days, 1 day each month, up to that maximum of 10 days per year. So it is accrued kind of the way that we think about vacation accruing. It's not, as soon as they've got 30 days, they're automatically hitting that 10 days per year threshold.
Right. Yeah. So there's interesting developments, and I think it's another area where there will be some discrepancies. If your friend is a federal employee, they all of a sudden have up to 10 paid sick days. If you're an Ontario employee, you don't. And so I think it's really important that people understand what their rights are specific to the nature of their employment. The other point, as you were talking, this just occurred to me, and we've talked about this before. PTO is a common thing. It's a very common practice in the States. PTO is paid time off. And I think a lot of employers try to simplify things. Instead of having vacation days and sick days and personal days, they just had this one big basket of days that you can take off, which sounds great and makes life really simple. But as we know, and I just want to mention this to viewers, it can get pretty complicated in Canada because, as you said, now if you have a federally regulated employee, they have their vacation entitlement. Let's say it's 10 days. Then they have another up to 10 days of paid sick days. So if you're offering PTO, I mean, first of all, if you're offering PTO of 15 days, you might now maybe be below your statutory requirement. But even if you're offering the right total number, how do you divide it up? So let's say someone is really sick one year and takes 10, or maybe you give them 2 extra days and they take 12 sick days that are paid. Well, now they may only have 8 paid vacation days left, which is less than statutorily required. So even though it's nice to have them all in one basket, you're going to have to delineate and make sure everyone gets their individual protections.
Yeah, that's a really, really good point. And I think the other thing that employers need to be really alive to is drafting. So when you are drafting these policies or your employment agreements and you're saying you're getting 20 days of PTO, you better be clear that that includes their statutory entitlement to vacation and sick leave and et cetera, so that they're not looking at this assuming, great, I'm getting 20 PTO days and then all of my statutory entitlements on top of that. And remember, any ambiguity is going to be resolved against the drafter, which is the employer in this situation.
Yeah.
So the really important thing to keep in mind as well.
That's a really good point. And just a good reminder to check your contracts, update your contracts as these things evolve. That's really, really, really critical. And I'll say it, work with your employment lawyer to make sure you're doing it properly. So I was going to move on to Saskatchewan. I'm also looking at the time and realizing that we've already gone 20 minutes. So I'm going to make the on-the-fly decision not to do a rant today because I think we need enough time to cover at least a few more provinces. And I can always do a video separately and get my airtime that way. But I know you want to talk about Saskatchewan and protection from potential COVID liability.
Yeah, I thought this was really interesting. And this was also something that came into effect as of January 1st. And this was part of a lot of different changes to the Saskatchewan Employment Act. So it was just one of a number of changes that I encourage you to, if you are based in Saskatchewan, to take a look at. But one of the ones that I thought was really notable was this general protection from liability for employers with respect to COVID-19 measures. So basically, what this does is it prohibits an employee from bringing an action against an employer if they're suffering some type of illness or even permanent injury as a result of contracting COVID-19, as long as the employer acted or made a good faith effort to comply with COVID legislation. And specifically, what they're talking about is any COVID-19 emergency regulations that applied to the employer, that they complied with those obligations and they didn't engage in anything that would be considered negligence or gross negligence. So it's providing this kind of protection for employers from adverse action by employees as long as the employer essentially did their best with the information that they had at the time, which I think is really interesting because, as we know, a lot of COVID-19 has been reacting on the fly based on the information we have, right? And governments doing their best with respect to putting out safety guidelines based on the information that they have. But, 2 months later, we might look back in hindsight and go, if only we'd done this, right? If only we'd made this change, but we didn't know at the time. And so basically what this legislation is doing is saying we're going to offer protection for employers who are following the protocols that were in place at the time, even if down the road we're looking back and going, we could have done better.
Right. And I don't mean to put you on the spot here, but have we seen this in any other province? Because I don't recall seeing anything like that.
I was actually just thinking about that as I was talking, and I'm not sure that we have. I'm wondering if there's another. It's definitely not Ontario, but if there's another province like Maritime or Prairie Province that has this stipulation as well, but I'm not 100% sure. It might just be Saskatchewan.
Yeah, we'll have to look into that. But I mean, even so, you think just on a regular negligence principle, if they were following the sort of prevailing wisdom at the time, then that shouldn't be negligent. But anyway, so we've got at least one province who has explicitly protected employers in that context.
Mm-hmm.
All right, why don't we move on to my home province now, Quebec, and talk about amendments to the Quebec Charter of the French language. I'm trying not to roll my eyes as I say that. Since all of the language laws in Quebec are the reason why so many people like myself graduated in Montreal and then left and moved to Ontario or BC or somewhere in the States. And the reason why the economy in Quebec is falling so much further behind the rest of Canada. And even the Bank of Montreal has its head office in Toronto. But anyways, maybe I should do my rant on Quebec language laws next time.
Yeah, right. You have a lot to say.
Yeah, it's only been about 27 years since I left Montreal. I'm not still bitter. Anyways, what have our friends in Quebec done now?
Yes, let's talk about it. So I mean, and this is kind of cool because we almost never get to talk about Quebec because their legal system is so different from the rest of Canada. So we often, and a lot of our clients will know, people who contact us, we avoid Quebec like the plague. We don't touch it with even a 10-foot pole. But this one
Yeah.
is
We
is
have good friends in Quebec that
we do.
that
We
we
have
will
people that we can reach out to and say, please help us with this.
yeah, we will get you the advice you need. We're just not going to do it ourselves.
Exactly, exactly. But this one I think it does bear talking about because I think it could have a significant impact on employers. And essentially what the new requirement is that certain contracts have to be provided to employees in French. So my understanding is previously, you could agree to have the contract be in English, and everybody agrees that there's no need for the French translation. That's now been removed. So the idea is for certain contracts, and the contracts in question are called adhesion contracts, which is basically contracts that are drafted by one person, right? They're drafted up and given to you to sign as the employee. There's not a lot of opportunity for negotiation or fine tuning those terms. So that's what is considered an adhesion contract. And those types of contracts, the new requirements are that those have to be provided to employees in French first. Then they can agree to have an English version be the actual binding version of the agreement, but it has to be provided in French first. So this means that for a lot of employers, they're going to have to incur the cost of having French translations of their employment contracts in order to make sure that they're meeting this requirement. Now, the only really good news out of this, other than, yay, language diversity, that's great. But the other good news is that when you're talking about contracts that are negotiable, right? So usually with your more senior management staff, anytime where there's back and forth negotiating the terms of the contract, this requirement would not apply. So it's really just for those adhesion contracts where you are saying, these are the terms, take it or leave it, basically. That's where you're going to have this requirement kick in.
Yeah, you took the words out of my mouth. I was going to say it's for the the lower levels of roles where it is a take it or leave it, not where you're negotiating. But it does bring up an important point. We work with clients across the country, and when we're adapting contracts for other provinces, I mean, generally it's a matter of looking at the employment standards in those provinces and adjusting things like holiday, vacation, overtime entitlements. It's tweaking. But when it comes to Quebec, because they're governed by the civil code and not the common law, there are very different requirements. And sometimes your contract does have to look quite different than it does in the other provinces. So that's one thing to bear in mind. And just on that point, because this is coming up a lot more these days with the prevalence of remote work, we're seeing this happen more and more often where, individuals either are moving away from where they're based or companies are taking advantage of the fact that they can hire somebody from anywhere. They don't have to hire somebody in the city where they're based. But I think it's important everyone remember that employment standards legislation is based upon where the individual employee is based. So in other words, your company might be based in downtown Toronto, but if you hire someone who's working in Vancouver, or if your employee who was in Toronto is now moving to Quebec, then the employment standards of that jurisdiction will apply. So the other thing we're doing a lot of lately is updating our clients' policy handbooks to adapt or to address policies and legislative requirements in other provinces when they find that even if they have one employee in a province, they've still got to make sure that they comply with that province for that employee. So that's a bit of a digression, but it's an important point for people to remember when they're thinking about allowing people to work remotely.
Yeah, that's a really, really good point, Stuart. And I think is one of the reasons that we were emphasizing and we're continuing to emphasize the importance of having a remote work policy, or even right in your employment agreements when you're talking about location of work. If you're going to allow remote work, making it clear right from the outset that if they are thinking about moving, they have to let you know, right? That there has to be some disclosure so that we don't end up in the situation where you find out after the fact that you've had an employee in British Columbia for a year and you had no idea because the requirements can be different.
Yeah, no, that's a great point. You should definitely put that in your contracts. And I don't know if you saw this. I saw something online recently. It was an article all about, I think it was like 6 people who had successfully misled their employers and worked from these exotic locations for the last year or two. Anyway, and kind of painted these people as heroes. They'd done their job, but they were living somewhere in Bali or wherever it was. And it sounded amazing. But of course, they were misleading their employers and all of their colleagues. And B, to our point, they may have been creating potential liability for their employers as well as tax liability for themselves. So you want to make sure to put that in the contract and make it sure it's absolutely clear that they should not be leaving the jurisdiction without letting you know. So I know we're just past 1 o'clock, and I think the one last thing I wanted to cover, unless there was something else you wanted to, was the changes to the Competition Act.
Yeah, I think that's an important thing to just quickly talk about because again, this is another piece of legislation that you normally don't see us commenting on. The Competition Act is kind of the federal piece of legislation that governs businesses that operate in Canada from a competition perspective. The name is pretty self-explanatory. So normally it doesn't have an impact for us on it from an employment law perspective. But recent changes were made actually back in the summer and will come into effect as of June 23rd next year. So we've got basically a year to sort this out, is a new criminal conspiracy offense for employers who enter into wage fixing or no poaching agreements with other unrelated or unaffiliated employers. So wage fixing refers to agreements that fix, maintain, decrease, or in some way control salaries or wages and conditions of employment. And no poaching obviously refers to agreements not to solicit or hire each other's employees. So interestingly, the reason that these amendments came up, is that is the hero pay kind of scandal that we experienced earlier on in the pandemic, where a number of employers offered higher rates of pay for those workers who were desperately needed, right? Like grocery store clerks, who we really needed to make sure were staying at work throughout the pandemic to keep our society functioning as normal. And they were awarded this, hero pay where they were given an extra $2 an hour or something like that. And then it seemed like at the same time, all of the employers canceled the hero pay. And so this is designed to prevent situations like that, where you don't have two unaffiliated employers collaborating with each other to agree, basically, okay, we all agree we're going to cancel hero pay at this time, or we all agree that we're not going to offer beyond this level of pay to all of our workers in this same industry. So it's designed to eliminate that, but obviously has pretty far-reaching implications for a number of employers, because it's not unusual, certainly we see this quite often, for an employer to have with, like, let's say their client, if they're a professional employer organization or they're a labor provider, a talent provider of some kind, to have a non-solicitation clause in their agreement with their clients that says, like, you're not going to hire our employees directly. So that's going to be, I think, could have a significant impact on a large group of employers.
And I think that's key. And we work with a lot of those labor providers. And obviously, it's very understandable why they don't want to recruit and train an individual and sort of serve them up on a platter to another company and then have that company steal them, which is why you've always had these no poaching agreements. But now, with the new Competition Act changes, that's going to be a very significant issue. So again, check your contracts, not only your employment contracts, but your contracts with your clients if you're in that business. All right. Any other legislative updates you wanted to comment on?
No, I think that's covering it. But I will just a plug back to our webinar tomorrow as well. I am covering legislative updates tomorrow during our webinar. It'll be only 10 minutes, but I'll try to catch anything that I didn't capture today. So tune in.
Awesome. Thanks for plugging that. So I guess we'll wrap it up there. So that's all for season 5, episode 10 of Fire Away. So I do want to thank everyone for tuning in, and Brittany, thank you for joining me in the guest chair this time. And just want to remind everyone at Rudner Law, we want everyone to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. I'll invite everyone again to keep up to date on employment law and all the changes by following us on Twitter or Instagram or LinkedIn, liking our Facebook page, subscribing to our YouTube channel, and of course, subscribing to our newsletter. And as we always say, none of that replaces legal advice that is specifically tailored to your specific circumstances. If you think you may need an employment lawyer, you probably do. So feel free to reach out to us. Past episodes can be found on YouTube, on our website, and on Facebook. If you like our page or subscribe to our channel, you get notifications when episodes are live. And lastly, stay tuned for our next episode, last episode of the year. We're going to do something fun for the holidays, and that will be on December 20th. Thanks to Rob, to Rebecca, and to Mark for helping put the show together as always. Brittany, thank you again for joining me. Thanks for tuning in. See you next time.